The Supreme Court takes a case to decide the constitutionality of and very important issues, obviously. But is there an ability to jump the line? There's a couple of major cases that are being discussed, and they're all major, I suppose, so that sounds like a ridiculous statement, but social media being protected under the First Amendment and something historic that could happen today. Our friend Evan Bernick is assistant professor at NIU College of Law. Because it's an election year, is anything related to the election likely to jump the line?
Hi, Steve. Well, some would argue that it already has. The Supreme Court has decided that it will review the D.C. Circuit's denial of Donald Trump's claim that he is immune from criminal prosecution, even after he left office, for acts committed while in office. Very early, at least in the court's timeline, they'll be hearing that case in April. They're moving very fast with it. And there's speculation to the effect that the court did that in the hopes of delaying his jury trial in connection with election subversion until effectively after the election. I don't know whether that's accurate, but the quick timeline that the court has moved on that really doesn't give much comfort to those who would take the view that the Supreme Court is immune from political considerations.
So you know the history of this court better than just about anybody. Are there decisions? It's obviously a majority conservative court. Are there decisions that are made and argued about behind closed doors where cases are taken with a specific agenda to affect politics? Because here's a bulletin, boys and girls. It's not supposed to be done that way.
So my initial read on that is no, but that is not to suggest that politics don't affect Supreme Court decisions. I will grant that there are a few contexts that I can think of in which I think it is fair to charge the court with very consciously seeking partisan outcomes. The leading example of this is Bush v. Gore, which basically saw the court handing the election to George W. Bush on the basis of legal principles that legal conservatives had abandoned or had never really shown much partiality towards until specifically that decision. But usually it takes place kind of implicitly. So the Supreme Court gets the hardest cases. It's majority conservative. In the hard cases, those are particularly the ones in which legal reasoning really doesn't yield very clear, direct answers. And so you have recourse to what you generally believe about the world, and that influences the decisions you make. And I think that happens quite a lot.
So should we be caught up in the fact that the court today may be violating some measure of standard operations and taking on this question about whether Trump should appear on state ballots?
I think that there is reason to think that the court would not have moved this quickly on it, but for the fact that it has implications for the fortunes of the presumptive Republican nominee.
So, Evan, I want to talk about this new case that the court's looking at, and that's social media platforms and the First Amendment. And they talked, I think that it got brought up last Monday, 7 days ago, where Texas and Florida are looking to have more control over these social media platforms. So the question is, they're privately owned companies. So they should be able to say who says what, when they say it, how they say it or not.
So I want to apologize in advance for how confusing this is going to get and how few definite answers I can give you, but all I can say is that the court made me do it. So you framed this just right. These cases involve First Amendment challenges to Texas and Florida laws that restrict the power of private social media companies to exclude certain users and kinds of posts on their platforms, generally called content moderation. Now, to hear the states tell it, these platforms are engaging in censorship of specifically right-wing views and posts. To hear the platforms tell it, the states are engaging in censorship. This is the equivalent of telling the New York Times what news is fit to print. And the justices seem to be somewhere in between, which I think is the right place to be, but it's hard to predict exactly what will happen.
And because it's hard to predict what will happen, the weirdness of this, to me, lies in the fact that these are publicly traded companies where the owners and founders of these companies and board folks and management are making millions and billions of dollars, and people's lives are being affected by them. So regulation would seem to be far more appropriate than is being administered to them now.
Right. So there are really three basic problems that are creating the confusion for the justices along the lines that you suggested. And first, it's that the justices don't seem to be entirely sure what these platforms are and what they do.
Oh.
So what does Etsy do? How is it different from what Gmail does? How about YouTube? What's the difference between like a conference call on WhatsApp and a one-to-one WhatsApp chat from the perspective of the First Amendment? Can Instagram ban Catholics? I mean, these are complicated questions, and it's not made any easier by the fact that even the advocates for these laws, defending Florida and Texas's laws, didn't seem to be entirely clear about their coverage, what they say, what they do. And then finally, just to add to this, suppose that parts of these laws are unconstitutional, but other parts aren't. Does the court strike all of them down? Some of them. Send it back down for further factual development. What you saw the court doing, to its credit, is really acknowledging the complexity and the difficulties of these questions. We need some measure of regulation of these platforms, which are incredibly powerful. And yet, these laws are so sweeping that the advocates for the laws themselves weren't able to tell the justices what they cover and don't cover, and basically are predicated on the view that these platforms just don't have any First Amendment rights, which even, the most pro-regulation justices on the court seemed uncomfortable with.
Last word, Jane.
Well, it's so interesting, too, because if it's a newspaper, you hire your journalists to write in the newspaper. So you're telling them, here's the story, go do your research and find it out. Social media, it's like, here's an open platform and say what you want to say. But if we don't like what you're saying, we're going to take it down. The interesting thing is that the court was looking the last time they had to go through this. It was many decades ago, and you can clarify this, but it was about a mall, and somebody wanted to pass out flyers. And was that freedom of speech passing out flyers in the mall, or can the mall say, don't pass out these flyers, we own the property? And they in turn said, no, we're looking at it like a town square. You can pass out any flyers or say anything you want in a mall. And now they've overturned that.
Right. So that's the case called Pruneyard, and you really kind of get the nail on the head with respect to how the court is thinking about this. Is that the appropriate analogy? Is this a shopping mall? The proprietor in Pruneyard really didn't have a viewpoint that they were taking with respect to leafletting. It's just that nobody could leaflet. Whereas these social media companies are exercising judgment in ways that reflect viewpoints. They are saying we don't want speech that promotes suicide. We don't want speech that promotes vaccine conspiracy theories. And the question is whether that is, as the states would put it, kind of a betrayal of what they say is their obligation as common carriers that are open to all comers, or on the other side, as the companies frame it, an exercise of editorial judgment that's protected by the First Amendment. So, weirdly enough, by saying for the states to say these companies are engaged in censorship, well, that sounds like they're expressing a viewpoint. And if they're private companies, then maybe that viewpoint is constitutionally protected. So I think that the court is really struggling with this, and I wouldn't be able to make any firm predictions, except that the court seems unlikely to take either the none of this stuff is constitutionally protected or all of this stuff is constitutionally protected perspectives that are being advocated by both sides.
It's Evan Bernick at NIU, and to me, it feels a little bit unsolvable, like the obscenity argument with George Carlin back in the day on the 7 Dirty Words. But nonetheless, we will have a resolution of sorts, even if it's just a first step resolution. And secondarily, we could get a decision today on the constitutionality of Donald Trump being banned by a couple of states, handful of states, including Illinois, from the ballot. And that's expected to go Trump's way, and we could hear as soon as this morning. Professor Bernick, thank you.
Thank you, Steve. Always a pleasure.
See you. I think he gave himself a headache when he was explaining it. Pretty sure.
It's very confusing.